Will the Supreme Court release its final decision in Dobbs versus Jackson Women's Health on Monday? Good afternoon, ladies and gentlemen. This is another Declaration of Truth from your host, Terry A. Hurlbut. In 3 parts, we look carefully at the draft opinion by Justice Samuel A. Alito in the Dobbs case. In part 1, we looked at how we got here, as Justice Alito lays it out. Then in part 2, we showed how Alito took the Roe and Casey cases apart and showed how they failed to establish a constitutional right to abortion. Now in part 3, we take apart that stare decisis doctrine and finish with a discussion of how the court nearly destroyed its reputation in trying to save it, and how it must uphold its decision now or get a real reputation for caving it will never live down. Before I begin, I want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom of that link. Lots of good merchandise there, including this t-shirt, Rhino Hunting. While I'm at it, I also want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well that even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is back-end, so you don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. Can't beat that with a stick. All right, ladies and gentlemen, our constitutional law class comes back from break, and here is part 3. We now come, as Alito does, to the stare decisis doctrine. He doesn't throw it out the window, but he does point out that the court has already set limits on it. Time does not sanction an error of the court in interpreting the Constitution. The history of the court is replete with such errors, which the court has corrected. Sadly, the one exception to this was Scott versus Sanford, and that one took a war between the states to correct. But as to the rest, the court made a clear mistake in Plessy v. Ferguson, 1896, and would not correct that until 1954 in Brown versus Topeka Board of Education. In correcting that error, the court set a record for how long it let a bad precedent stand before overruling it. For 58 years that precedent stood. Against that, the court would act more timely by reversing a 49-year-old error. Again, that's the record. Most reversals happen far more quickly, say in 12 or 9 or even 3 years. Alito sets 5 grounds for overruling a bad precedent. They are the nature of the error, the quality or lack of quality of the reasoning behind it, the workability of the original rule, the effect on other areas of law, and the interest of various parties that rely on continuing the error. By all such standards, Roe and Casey must fall. Alito's quarrel with Roe and Casey was that it took a question no court should settle out of the hands of legislatures and the people. Alito doesn't actually say that abortion kills a baby. Rather, he says that people cannot agree and the court shouldn't try to settle that one way or another. The court tried in Roe and Casey and shouldn't have. He also found the reasoning very weak, especially given the viability standard. Viability depends on best medical practice and research. It's gotten better all the time in the hands of doctors having patients who desperately want to save young lives. Which leads to its next objection. Viability and undue burden don't work. They don't work because who's to say whether an unborn child is viable or not, or whether a burden is due or undue? He shows bad effects on other areas of law by citing case after case in which the court has carved out exceptions to long-standing principles of jurisprudence. Now, about that reliance interest. A court creates a reliance interest when people must plan and act and know far in advance whether that act will still be legal. In nearly every single case involving abortion, people do not plan for it ahead of time. Furthermore, even the Casey opinion conceded that, and I quote, Reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions, unquote. When might the court upend someone's plans? Some women have said on social media that if Roe goes, hookup culture goes with it. Several have already said that they will no longer have sex casually. When they express a fear of pregnancy, they concede that no contraceptive method is foolproof. One woman said, and again, I quote, "Since about 75% of men only care about sex and money, I hope they know that this Roe v. Wade decision could destroy hookup culture and leave them paying 18 years of child support," unquote. Lay aside whether that statistic is accurate or not. Let me tell you something. To force any man to accept responsibility for the children he sires in or out of wedlock can only be good for civilization. Must our society permit abortion in order to let women take equal part in American economic and social life? Alito defies any court to answer that. Well, I have an answer. No. The question assumes that motherhood gives no value to society. That's a lie. And it also denies that men have any similar obligation to balance work and family life. That's another lie. I don't have time to go into that today, but maybe someday I will. The Casey court said one other thing directly relevant to current events. They said that overruling Roe entirely would shake the public's faith in the court. The court, by this theory, must stick to what it has decided or leave people wondering whether it caved to public pressure. Public pressure works both ways. I won't deny the history of Marches for Life because I actually took part in 4 of them. But never at any time did march organizers even think of demonstrating in front of homes of justices most likely to decide to uphold Roe and Casey. That's probably because we knew that that's against federal law. Justice Alito says the obvious. You do not let error stand permanently. The court didn't let Plessy v. Ferguson stand, and not more than 1 or 2 people would have wanted that to stand. So if anything, overruling Roe and Casey, far from shaking public faith in the court, would restore it. Last, Alito applies rational basis review to the matter at hand, the Gestational Age Act in Mississippi. He identifies 5 bases for upholding this law: respect for and preservation of prenatal life, protecting the health and safety of the mother, eliminating a gruesome medical procedure, and preserving the integrity of the medical profession, relieving pain and suffering of the unborn child, and preventing discrimination. The first 4 by themselves justify stopping abortion after 15 weeks, and as Dick Morris has shown, maybe number 5 would justify banning abortion entirely. Forget about Margaret Sanger's expressed intentions. Just look at this abortion's effects. Now then, the draft opinion orders remanding the case to the Fifth Circuit, telling them to decide the case knowing that Roe and Casey no longer apply. Even Chief Justice Roberts would agree with that, though for reasons he has not yet made clear. Sadly, someone has already tried to influence the court by leaking the draft. This case has paralyzed the court as no other case before this. As Alito points out, the court tried to protect and stand on its prestige and lost. Events have also vindicated Thomas Jefferson, who decried the idea that, and I quote, "the Constitution is a mere thing of wax in the hands of the judiciary, which they may twist and shape in any form they please," unquote Thomas Jefferson. To which Alito now cries, enough, or in the language of his ancestors, basta. Then someone leaked his draft, after no other member of the court wrote anything in reply for nearly 3 months. Now Alito and his family have had to leave their house and hide. Someone has poured contempt on the court, and it's not Justice Alito, and it's not anyone on the pro-life side. Again, the Supreme Court has an opinion day next Monday. We'll see whether they release an opinion in Dobbs. If the court wants to preserve its dignity and integrity, it will stand on Alito's opinion. Furthermore, Alito will acknowledge and rebut Roberts' concurrence and 3 likely dissents, and the court can then move on. Links to the description of the article, to the Alito Draft, to the many videos I have already recorded on this subject, and to conservative news and views. I have another link to the awesome online store and to BitNext, as I mentioned. And if you like what you've heard, you can like this video and subscribe to this channel. This is Terry A. Hurlbut, delivering another declaration of truth and reminding you to let the truth set you free.